Take the microphone. There.
Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Tuesday, May 19th, 2026. The time is now 9:02. Court is now in session. Assisting us today is Cecia Rodriguez, court administrator and interpreter. Ms. Gloria Noriega is the court coordinator. Ms. Liza Rodriguez is the probate court investigator. Video conference co-hosts this afternoon and this morning include Mr. Lopez, Ms. Rodriguez, Mr. Hernandez, Ms. Lozano, and Ms. Rodriguez, the other Ms. Rodriguez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Noriega or Ms. Rodriguez.
First in person is Counsel to page 1, number 2.
Ana Guzman versus Roberto Castro, cause number 2013 CVL 2313C3. Court marks Ms. Soto present in person, Mrs. Cotto present by video conference, Ms. Garcia present by video conference. Is anybody here on behalf of the Attorney General's office?
Yes, Your Honor. Joshua Schamberger with the Office of the Attorney General.
Welcome to court, Mr. Schamberg. The court marks you present by video conference on behalf of the AG's office. Are you Roberto Castro?
Yes.
Court has heard yes. Welcome to court, Mr. Castro. Court marks you present in person. The person to your left is your lawyer, Ana Guzman. Are you present?
I'm
Court
present, video conference, Your Honor.
Court staff will identify and prompt. Ms. Guzman, please turn on your video. And unmute your device.
There you
go. Are you Ana Guzman?
I am, sir. Yes.
Welcome to court, Ms. Guzman. The court marks you present by video conference. As you can see from your device, your lawyer is also present by video conference. Ms. Soto, Mrs. Cotto, go ahead.
Good
Your Honor,
morning, Judge.
Good morning, Judge. We did confer with the help of Ms. Garcia. We were able to reach an agreement, and I believe Mrs. Cotto filed that agreement as of this morning.
Good morning, Judge Madeline Escoto for Ms. Guzman. That is correct, Judge. With the assistance of Ms. Garcia, I'm glad to report to the court that last night I prepared a settlement offer. That offer, pursuant to her recommendations, has been e-filed with the court. We're asking that the court approve the same. The only change, and my client has agreed, is that on Friday, Mr. Castro will return Bobby at 9 instead of 8 at Ms. Guzman's residence, as there's a family graduation going on.
To be clear, this is 9 p.m.
9 p.m. instead of 8 p.m.
Ms. Soto?
That's correct, Your Honor.
Ms. Garcia?
That's correct, Judge.
Mr. Schamberger?
Well, I haven't seen it, but just for the support terms, what was in the agreement, just so that we know.
So this particular case is a modification. There is no support on this case based on the prior order, and health and dental is in the prior order as well. And that's
I see the health and dental. Yeah, so I didn't know if that was continuing.
Yeah, it's safe. Nothing's changed.
Okay, then we're not opposed to the agreement, Your Honor.
Mr. Castro, do you have any questions for the court?
No.
Court has heard no. Ms. Guzman, do you have any questions?
No, Your Honor.
Let me ask the clerk's office. Ostensibly, it hasn't been processed yet. Is there any way to print out?
It has not been processed, Your Honor, and I don't have access from this computer to accept it.
But you can see in your, can you see that it has, in fact, can you confirm that it's been e-filed?
No, since I don't have access to the website.
Can we verify, Ms. Noriega, on our system?
I believe we can. Let me see if we can get staff inside to go ahead and check that.
Was the court e-served?
It was done at 8:40, Judge.
Was
And,
the court e-served at CC2 filing?
Yes, ma'am.
Yes, Your Honor, we see it.
Is there any way for you to pull it out of that queue or that email?
Yes, Your Honor. It hasn't been file marked. It hasn't been accepted by the clerks, but we can print out for your review or
Yeah, yes, please, because at the time that I sign it, the file mark will be removed anyway, so they can still process it, but I would prefer to sign it than alleviate another administrative step between now and Friday. All right. Court staff will print, the court will sign that Rule 11. Now, to be clear, Ms. Soto and Mrs. Cotto, the change for from the 8 to the 9, is it in there, or are you asking that the court delineate that in there?
I don't think it's necessary, Judge. We put it on the record. The parties understand the change. It was requested after the filing was done, but I don't foresee a problem.
All right. These are the orders of the court. The court will adopt and approve. The court will sign off on the Rule 11 agreement. The formal temporary orders are due to the court on or before.
June 29th, Your Honor, at 12 noon by submission.
Sure. They'll get filed before. I'll sign them before. Anything else on this case, Ms. Soto?
No, Your
If-
Honor, I know we're set for court on June 18th. If the parties should have a need to come back before the June 18th date, is there a date available for the courts?
If they wanted to do what now?
Earlier setting than the June 18th, that's when we have our final pretrial conference.
For the purpose of a prove-up or a
Correct. Or if there's a motion that needs to be filed, there are any dates before that June 18th date?
for a contested setting?
Correct.
We do have dates, and the court will entertain that as soon as the request is
Okay.
made. So it's a hypothetical if
Yes.
that happens, but ostensibly, well, it's set for final pretrial on the
June 18th,
18th.
yeah.
I think the reason the court did that so that you all go straight into a contested on August the 11th if needed.
And Judge, I
I guess what we envision is Ms. Garcia will come back with additional recommendations as what is going to happen over the summer visitation. And so I'm hopeful that we can progress like we just did today with an agreement as to what will happen during the summer.
All right, well taken. If you need a setting, just request it. Ms. Soto, Mrs. Cotto, the court staff, our court administrator has printed out the not yet filed mark Rule 11. I'm tendering that signed copy to the coordinator and instructing that it not be filed until the original is file stamped, and then this one will get e-filed. So you'll get that soon.
Thank you, Judge.
All right, Ms. Guzman, Mr. Castro, keep in contact with your lawyers. I wish you both and your children all the best.
one more, Judge.
Thank
I
you.
Uh,
have subpoenaed two witnesses for today, Ms. Itzamara Nava and Ms. Margarita Tawada. They should be on the well of the Zoom court.
Ms. Nava, are you present? Ms. Tawada, are you present? Court has reviewed all devices, none with those surnames.
And
Right.
I had released my Marla Lanis, Judge, based on the fact that the court had instructed her if we reached an agreement, she didn't need to appear today.
All right, very well. We'll see you all on June the 18th. Good luck to all.
Thank you,
Thank
Judge.
Thank you.
Next case is page 3, number 9.
Page 3, number. One more time.
Page 3, number 8.
Irma Ramirez versus Ismael Ramirez Jr., cause number 2025 FLA 929C3. Court marks Ms. Soto present in person, Mrs. Cotto present by video conference, Ms. Garcia present also by video conference. Irma Ramirez, are you present? Ismael Ramirez Jr., are you present? Court notes no parties are present. Ms. Soto, Mrs. Cotto, go ahead.
Judge, we did file an agreed motion for continuance yesterday for the court's approval.
And Madeline Escoto for Ima Ramirez, Judge. The parties had their son's awards ceremony this morning.
Hmm.
And so we submitted the continuance based on that fact, and we attended mediation with Ms. Cigarroa, Judge. And so I'm just pending from Ms. Soto a partial mediated settlement agreement on the things that we did agree to. And then we'll come back and have a full-blown hearing on those issues that we did not settle.
For the court's benefit, I guess, tell the court what the themes, the topics of disagreement, the things not yet settled. Is it conservatorship or
It has to
property
do,
interest?
it has to do with the children, Judge. There is a sober link device that the parties discussed that. And so the one of the issues is for how long, and then who would pay that for father's use.
And
Ms.
just to clarify that point, so that was requested. My client did not agree at all to sober link. It's for detecting alcohol, which is not a vice of my client's vice. He agreed to propose hair follicle test, but he did not never agree to sober link. So the issue is visitation, Judge. When overnight start, when what the process for supervised and unsupervised visits would end. And the property division as far as debt and retirement benefits.
And I think the court heard Mrs. Cotto say that mediation has been attempted with Ms.
Yes.
Cigarroa,
Yes,
Correct, Judge.
we did
And-
a full day.
and certain issues I think the court also heard had been agreed to. So it was a fruitful but not completely dispositive mediation.
Yeah. And what we agreed was that Ms. Soto, Judge, there was a mediator's proposal circulated. And so what I've told Ms. Soto, the faster she sends me that partial mediated settlement agreement, the sooner we'll know exactly what the issues are for the court's consideration. And I'm open to an informal settlement conference with the court if Ms. Soto does not oppose that as well.
I'm not opposed to an informal, Judge, and as far as the mediator's proposal, I did advise Mrs. Cotto that I was going to review with my client, because when he reviewed it, he rejected it in its entirety. But I did represent to Mrs. Cotto that I was going to sit down and review that with him again to see if there could be some agreements reached on that proposal so that we could narrow down the issues for the court.
Interesting on all fronts. Understood. So let's work backwards. First, as to the continuance, this is the fifth setting, and I swore to myself when this docket began that cases with this many weren't going to get continuances. But for full disclosure, I empathize with the parties, which is why we're not doing 2 p.m. We're doing 9 a.m. So I certainly empathize with graduations and ceremonies at this time of the year. So well taken, and cases continued. Ms. Noriega, give us the next setting, please.
In 30 days, Your Honor.
Well, give us the next available, because I'm gonna give them another date in between as requested. So whatever. Go
Yes,
ahead.
Your Honor, that'll be June 16th at 2 p.m.
Let's see what we have. Say it again.
Dismiss.
All right, the one available setting with Associate Judge Martinez. Ms. Soto, any conflicts Tuesday, May 26th, 1:30?
Judge, I'm mediating a case, as a mediator for Mrs. Cotto and Mr. Sanchez on that date, I believe in the morning, so just make sure that it's in the morning or afternoon, give me 1 second, so it's in the.
It's in the afternoon at 1:30.
Okay, so then I can do June 16th in the morning, Judge. June 19th, I'm sorry. May 26th, right? May 26th.
I'm sorry, so what was it, so May 26th?
In the morning,
No, at 1:30,
I'm mediating a case for Mrs. Cotto and Mr.
Okay.
Sanchez on that date.
right, so.
And I know that the court is looking at Judge Martinez's schedule. Would the court entertain us yourself?
Yes, that's step 3. So I'm eliminating
Okay.
JLM, Judge Martinez, and I think Ms. Soto may have done that for us already. So, and then I'm gonna look at my dates. Let's do this. Ms. Soto. First question, any conflicts June the 4th at 9?
None, Your Honor.
Same question, Mrs. Cotto?
No conflict, Judge.
All right. I'm gonna schedule this for about 2 hours, 9 to 11. So if y'all can work on the debt, I have no idea what the issues are with the debt. So so our time on June the 4th is going to be limited, but the issues of sobriety and sober link and overnight visit, I'm pretty sure I can bat that out for you all pretty quick, or at least help you walk you through some of the contemplations with your clients. All right, I've calendared myself for this on June the 4th, 9 to 11. All right. Then we'll come back on June the 16th at 2 p.m. if necessary. If not, we can put stuff on the record on that date and give you an orders due. Ms. Soto, anything else on this case?
No, Your Honor.
Mrs. Cotto?
Judge, and I'll be there in person with my client.
Yeah, so all of these are in person.
Yes.
Yeah. All right, Ms. Garcia, you're welcome to participate or be on standby, either one.
Thank you, Judge.
All right, thank you all. Ms. Rodriguez, yes,
I'm sorry, this case continued to,
June the 16th at 2.
okay, thank you.
Next is page 5, number 12.
Laura Mónica de la Garza versus Jose Manuel Valdez versus Gilberto Eric Reina, cause number 2025 FLK 1395C3. Court marks Ms. Soto present in person. Ms. de la Garza, Mr. Valdez, Mr. Reina, any other persons present?
Judge, my clients are not present. The last time we were here, the court had noticed that the respondent father had already been served by substituted service at his home address by leaving the citation at the front door. He's never made an appearance, has not responded to emails. The court did ask me to file an order to appoint an ad litem, and I did do that, Your Honor. You requested that back in March of 2026, so I did file a motion to appoint a guardian ad litem for the child.
Wow, has that been signed?
I don't have a signed copy, Judge.
All right, this is on fire. The court will, well, this is a docket control conference.
Yes.
All right, so the court will sign that. And is there any lawyer that you know would have a conflict?
I don't believe so, Your Honor.
All right, I'll sign that and we'll come back for a final hearing in 30 to 45, closer to 45. Ms. Noriega.
I'm sorry, Your Honor,
30 to 45.
30 to 45 days, that'll be July 7th at 2 p.m.
All right. Ms. Rodriguez?
That'll be it for Council.
Judge, I have one more.
Yes, that's page 4, number 9.
Jorge Martinez versus Denise Marie Salinas, cause number 2025 FLA 1199C3. Court marks Ms. Soto, present in person, Mr. Castillo, present by video conference. Jorge Martinez, Denise Salinas. Any parties present? Good morning, Mr. Castillo.
They're not present, Judge.
All right. Good morning, Ms. Soto. Good morning, Mr.
Judge.
Castillo. Counsel, what is the announcement?
Judge, I did confer with Mr. Castillo yesterday. We have been exchanging settlement offers and we've tried to confer. There are some sticking points that would need to be addressed by the court. However, my client was not able to obtain a day off of work. And I know that the court should take precedence, but he did want to participate by Zoom. Because of the nature of the case and testimony, I thought it would be easier if he was here present without any distractions. So I did ask Mr. Castillo if he could graciously agree to a continuance, and he did. We just need a short one, Judge.
Mr. Castillo?
That's correct, Judge. We just need a short reset, maybe a couple of weeks or.
All right, well taken. I think this is the first setting, but two points. First point, I think on April 22nd, the court granted a transfer and consolidation. Has an order been
So,
filed, prepared?
Judge, I don't have the cause number, but I will get that today. I have the order, but when I was working on that order for the court.
Let me give it to you.
Yes.
It's 2024 FLI 001427C1.
I have it ready. Just need to add the cause number, Judge. You filed it today.
The motion for continuance is well taken. Ms. Noriega, give us next available, very next available.
Very next available is June 4th at 2 p.m.
And I'm very glad, Mr. Castillo and Ms. Soto, that you agreed to this sometime in the very near future, sometime between July and October. I think the court will come out with some local rules making contested hearings mandatory in person for parties, not so much for witnesses, but for parties and counsel. So just be on the lookout. But it's agreed to, so well taken.
Thank you, Judge.
Thank you all. Any other cases for Mr. Castillo?
Judge, what is the reset date, please?
June the 4th at 2 p.m.
Before.
I have one.
Yeah, 1 minute.
Okay, I don't have anything else, Judge. May I
Good
be
to see you,
excused?
Mr. Yes, sure. Good to see you. Have a great day.
You too, Judge. Thank you.
Page 3, number 6, Your Honor, for Ms.
6, yes.
Yes,
Linda Lizette Flores versus Joey Hernandez Quiroz, cause number 2019 FLH 1067C3. Court marks Ms. Soto, present in person, Ms. Aldana, present by video conference. Good morning, Ms. Aldana.
Your Honor. And I was gonna
Court marks Mr. Joshua Schamberger, present by video conference. He's here on behalf of the Attorney General's office. Speak into the microphone and tell the court, are you Linda Lizette Flores?
Yes, Your Honor.
Welcome to court, Ms. Flores. Court marks you present in person. The person to your left is your lawyer. Unmute your device, Mr. Hernandez, and tell the court, are you Jolie Hernandez Quiroz? There's an unmute button at the bottom left of your device, or your screen's device. Press that button, please, to unmute yourself.
Present, Your Honor.
Welcome to court, Mr. Hernandez Quiroz. The court marks you present by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Ms. Soto, Ms. Aldana, go ahead.
So Ms. Saldana filed a motion for enforcement on daily calls and passport application. I did file an answer. Last night, Ms. Saldana filed an amended motion to enforce. I also consequently filed my own motion for enforcement and motion for substituted service on Mr. Hernandez. So if I can just have a couple of minutes to confer with Ms. Saldana, and the court can put us on recall on this one.
Ms. Aldana?
I'll confer with Ms. Soto.
All right, this will be marked as the first contested matter on today's docket, so that folks know we have a hard stop at 11:30, so good luck to all.
Thank you, Judge. Judge, is there a hard stop at 11:30 for the whole day?
Yes.
Or, okay, all right.
Next in person, Council Marcel Notson, page 10, number 27.
This is in the estate of Edna Bernadette Carranza, cause number 2026 PB 718L2. Court marks Mr. Knotson present in person. Good morning, counsel.
Good morning, Judge. Good to see you.
Likewise, court marks Mr. Bruce Warstack present by video conference. Good morning, Mr. Warstack.
Good morning, Judge. And I do have
Denise
Denise Nixon Bunk is present.
is Bunk. Please step in front of the microphone and tell the court, are you Denise Nixon Bunk?
I am.
Welcome to court, Ms. Bunk. The court marks you present in person. The person to your right is your lawyer. Ms. Bunk, who is the person on your left?
My brother, Jonathan Nixon.
Jonathan Nixon, you're on.
Mr. Nixon, welcome to court. The court marks you present in person. Mr. Knotson.
Yes, Judge, we have our amended application to determine heirship and for letters of administration. We'd ask the court take judicial notice of the contents of the court's file. Mr. Warstack already filed his report. We have agreed to his fee of $1,600, which I think is reasonable and necessary. That's been paid as of yesterday. We put that in the proposed order judgment to determine heirship for the court's consideration. And we do have the witnesses here, my client, and there should be two other witnesses.
What are their names?
Al Pintor and Ronnie Martin Munge.
Mr. Pintor, are you present?
And also Mr. Warstack met with them and verified all the information in their affidavits.
Mr. Pintor, turn on your video and your microphone, please.
What?
Mr. Pintor?
Yes, Your Honor, my video is on.
It is not. So is there another device, a cell phone, another laptop, desktop, tablet, or anything else you can you're not going to be able to testify if we can't see you.
I don't think we'll need them, Judge, unless you think it's necessary.
What was the purpose of calling this person?
No, just have them available for Your Honor, that's all.
Oh, may or may not be necessary. And who was the other witness?
It was Ronnie Martin Munge.
Munger.
Is it
Munger, sorry.
Is it, I apologize. Is it Mr. or Mrs. Munger?
Mr.
Mr. Munger, are you able to turn on your video?
No, I'm not.
Are they in the are you in the same location as Mr. Pintor?
Yes.
Not going to make a difference. If so, do you need these witnesses?
No, I don't think you do, Judge.
Well,
I just wanted them here as, courtesy to Your Honor.
sure. They're not going to be able to testify without being able to see who they are, being able to place them under oath.
That's fine.
Let me see if I can summarize the court's understanding, Mr. Knotson. If this is incorrect, let me know. So this case was filed by, I believe, Ms. Carranza's now deceased husband. It was filed by Mr. Perez, and then there was a substitution both for counsel and applicant, and ostensibly the applicant at the time, Mr. Carranza, passed away, and pursuant to Mrs. Carranza's will, Ms. Nixon is the successor for administration.
Yeah, she was named there, but Judge, we're going under independent administration and letters testamentary, because if you look at the original will was never found. And Mr. Warstack noted, my client noted, I noted, my paralegal noted that on the application that was filed, the self-proving affidavit was the one of Henry Carranza. It wasn't the one of their mother. So it's not even complete. It's not a valid will. And Mr. Warstack noted that the original was never found, that we do know. So that's why I thought and believe this would be the most appropriate way to proceed forward. They're the only two children of Ms. Carranza and her former husband, Dennis Nixon. And Mr. Worstak correctly identified, basically Mr. Carranza's estate is going to get 50% of any community property they own, any separate property, real property that she did have before she got married from her ex-husband is 50% Denise and 50% Jonathan is the daughter and son. So, and personal property is 2/3 separate personal property, 2/3 to the children and 1/3 to Mr. Carranza. So basically, I think the proposed judgment to determine heirship is appropriate, and the order granting the amended application for letters of administration. And we appreciate the court setting this for hearing because the mother did have a business, a home healthcare business, and Mr. Pintor is an expert. He's also an attorney on healthcare law. And once Mr. Carranza died, there's nobody there to administer it that has a license. And that's what the urgency was, to get the letters of administration.
I think you've answered the procedural questions I
Thank you.
had. That makes sense. And Mr. Worstak can give his report orally. I have the physical copy
Thank you.
and I reviewed it, but anything that you want to fill in, any logical or procedural gaps, you can do so momentarily, Mr. Worstak. Mr. Knotson, who is your first witness?
Worstak.
Mr. Worstak, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do.
Mr. Knotson.
Yes, you were appointed by the Honorable Judge Villarreal in this case, correct?
Yes, yes.
Tell the judge what you did in this case. Briefly.
The report, Judge, that I filed, can I testify in a narrative form, or do you want me to go question and answer, Judge?
Narrative is fine.
There's no objection. You may.
No objection.
So I filed a report in this case on May 4th, 2026, that it speaks for itself, but it states all of the everything that I did in this case to represent the unknown heirs and determine who I think is entitled to the respective shares and interests of the real and personal property of this decedent, which is contained in my report.
All right. And have you reviewed the proposed judgment that we submitted to the Honorable Judge Villarreal?
Yes, I have. The judgment was filed on May 4th, 2026. And in paragraph 5 of my report, I stated that, in my opinion, it correctly stated to the decedent's heirs and the respective shares and interests in the real and personal property of the decedent. I will say that there was another form of the judgment filed yesterday, and the only difference is it included the ad litem fees, but otherwise it is identical to the first one that was filed on May 4th.
Okay. And have the ad litem fees been paid?
I'm not sure that they have, but I don't have any problem. I'm sure they will be if they haven't been.
I think my wife took by the check to your office at 5 yesterday. So
thank you,
But-
Marcel.
all right, Judge, I do have the proposed order.
So Mr. Worstak, question could you crystallize and flesh out the procedural issue that that court asked Mr. Knotson responded to about proceeding under an heirship versus the original filed will?
So Mr. Knotson correctly stated, when I reviewed the file in the beginning, that there was an abnormality with the will that was presented for probate. But beyond that, I really don't have an opinion on that, Judge, because I was appointed to represent the unknown heirs in the heirship proceeding. And so my duties don't go as far as whether it's probated as a will for letters testamentary or an independent administration by agreement.
Say that last part again. Your duties are to what, and how does that affect the final outcome?
In other words, Judge, the order appointed me as an attorney ad litem to represent the unknown heirs in the heirship proceeding. So my duty, once I determine heirship based on what I've done in the case, then the case proceeds to the probate by agreement.
The administration.
And my duties are done at that point.
But you're not expressing an opinion as to whether you're not, in other words, you're not expressing an opinion as to the alleged abnormality in the will?
what I saw with the will, Judge, is that it was a will signed by the decedent, but the self-proving affidavit was signed by the decedent's spouse.
Prompting the necessity for an heirship. So that would make sense. All right.
That's correct, Judge.
Anything else that you would like to put on the record, Mr. Warstack?
No, Your Honor.
Any other witnesses, Mr. Knotson?
I'll call Denise Bunk.
Ms. Bunk, would you raise your right hand, please? Do you swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Please state your name for the record
Denise Nixon Bunk.
and what's your relationship to the deceased?
She was my mother.
And Jonathan Nixon, who is he?
Jonathan is my younger brother.
And did your mom have any other children?
No, she did not.
No one that was adopted.
No, she adopted no children.
And you've been an attorney for how long?
32 years.
And you live in San Antonio?
I do.
Okay. And basically, you also reviewed the proposed will that was tendered?
The copy?
Yes.
Yes, I've only seen a
And
copy.
the original was never found.
No, correct.
And basically, you also noted the same abnormality that Mr. Warstack noted.
Correct. The self-proving part was defective.
Okay. And that's why we did the application to determine heirship and for issuance of letters of administration, correct?
Yes,
And you're requesting that the court appoint you as independent administrator?
I am.
And basically, you understand you will agree to perform your duties faithfully, collect all the assets, pay any
I just
debts
want to
that
confirm
are-
that you're seeking testimony as to the administration at this point. We haven't concluded the heirship.
Okay, well, just on the heirship, so you're asking the judge to grant the judgment to determine heirship, who the proper heirs are.
Correct. Yes,
There's no other unknown heirs as stated by the attorney ad litem.
that's right. There's just my brother and I. We're the only children of Edna Burnett Carranza.
Okay, that's all I have, Judge.
All right, Ms. Bunk, in your mother's case, cause number 2026 PB 718L2, the court at this time finds that it has jurisdiction over this case. I would say the next things, but I know it's going to make more sense to you, and partly it's not necessary, but that means that this is the right court form and venue to consider determining heirship for and on behalf of your mother. The court hereby takes judicial notice of the entire case file, which includes the original will, the original death certificate, the citation by posting, citation by publication, both to the Office of Court Administration and with the Laredo Morning Times. The report, the filed and written report of the appointed attorney ad litem, and now the court has also had the benefit of his testimony and yours. Court also takes judicial notice of the waivers of both you and your brother. For all of these reasons, the court finds that the court has sufficient information, evidence, and testimony to declare heirship. The heirship of Edna Bernadette Carranza, also known as Bernadette Carranza, is hereby declared. Denise Nixon Bunk, Jonathan A. Nixon, and Henry Carranza, her now deceased husband. The court finds that Mr. Warstack has performed legal services in this case. The court finds that $1,600 is reasonable, necessary, agreed, and not objected to. Heirship is so declared.
Thank you so much.
The court is signing the last filed proposed order that includes Mr. Warstack's fees. Mr. Warstack, anything else on this case before the court releases you?
Nothing further, Your Honor.
Does Mr. Warstack have any other cases?
No, Your Honor, I believe that is it for Mr. Warstack.
Good to see you, Mr. Warstack. Have a great day.
Take care.
Court
Thank
is
you, Judge.
tendering the original signed judgment declaring heirship to the coordinator, Mr. Knotson.
Yes, Judge. Here, we'd ask the court take judicial notice of the contents of the court's file. I will call my client, she's already been sworn, just to finish up her testimony and see if you have any questions for her.
You may proceed.
Okay. We did file the amended application for letters of administration, correct?
Correct.
And you're requesting to be appointed on behalf of your deceased mother's estate.
I am. Yes.
And we did ask for expedited hearing, which the court granted, and we're hearing today. And you understand you're requesting to be appointed the independent administratrix, and you're requesting to serve without bond, but you're willing to post any reasonable bond the court deems necessary.
Yes, I am.
Okay, and you want to gather your mother's estate. She has a separate property on Surrey Road that's already been remodeled, and you all want to put it on the market, but they'll have held off doing so until you get appointed properly.
Correct. That's right.
And basically, there's also the business that your mother owned. And you want to make sure that that's closed within the proper rules of the Texas Department of Health and Human Services to make sure there's no penalties or liability on your mother's estate, correct?
Yeah, absolutely.
And basically to pay any all other debts your mom may have.
Correct.
And then distribute it pursuant to the order the judge just granted previously.
Yes, I will.
Okay. And you're willing to sign the oath of independent administrator of the court of Lucy.
Yes, I am.
That's all the questions I have, Judge.
Any other witnesses?
No other witnesses.
I guess the question I have, and I guess only regarding bond. It has, do you know, Mr. Knotson, if any person has filed for probate of Mr. Carranza's estate?
Yes, basically there was, they filed in county court 1. I think that's not set for hearing yet, or maybe it just got set. But Mr. Carranza has 1 daughter and 2 grandchildren. So, so basically, but the person that applied had a power of attorney for him. So regardless, his estate's gonna get 50% of any community property. So it's like that goes there. So that's not disputed, and he will get that.
Ostensibly, yes. Hypothetical until it happens. I agree. So far, the issue on bond would be a lot easier, and if it had been randomly assigned to county 2, but because it's going to be heard somewhere else, I must set a bond. So the
That's
question
fine.
now is, without holding anybody to it until you all turn in an inventory, what does anybody here believe would be the value of the community estate?
The value.
The community estate,
That's why I'm not holding anybody to it. You'll
right.
have to go doing some homework.
And that's
before.
why they don't have access to bank accounts because it's under the business name. And, you know, basically Mr. Carranza was doing that, and he gave a power of attorney to the lady that worked there for many, many years. So basically,
I just don't want to set too high or too low of a bond. Give me
Right.
what you believe would be reasonable and necessary.
a reasonable bond would be $5,000, Judge, unless you think it should be higher.
But you said there's a business involved?
Yes,
Is
Well-
that business community property?
yes.
Yes, I don't think it has much value. I think it just needs to be wound down because it's a home health care agency that, you know, my mother was the sole license holder of the Medicare license, so it's not going to be purchased or bought out by anybody. You can't transfer that necessarily. So we're just going to try to wrap it up.
And other than winding down a business, what other community property do you believe is part of Mr. Carranza's estate?
There was a small condominium in San Antonio. Unfortunately, in January, it caught on fire and burned down. So I don't know the extent of the rebuild. I wasn't in charge of that, so I can't really place a value. But even before, it wasn't much. It may be 150,000 condo that's since burned down. And then a building that they were operating the home healthcare agency out of off of Chihuahua Street. So that was, I believe, community property. And then bank accounts, you know, they were in their 80s, so retirement accounts, basically. So.
Mhm. Mr. Nixon, you've been listening here patiently to everything that's been said, stated, and testified to before I pronounce a judgment. Is there anything that you would like to say? I want to give you an opportunity to speak if you would like to do so.
I think, my sister said, we've already talked before. So-
Just want to give you that right and opportunity. All right. Anything else on this case, Mr. Knudsen?
No, Judge, thank you.
Ms. Bunk, in your mother's request in her case for administration, cause number 2026 PB 718L2, the court finds that it has jurisdiction over this case and this matter. The court hereby takes judicial notice as it did before. The court finds that there is a necessity to administer your mother's estate. The court finds that you are qualified and you are not disqualified from serving. The court finds that you have met all of the requirements for the court to grant your request. The court hereby grants your request and will cause letters of administration to be issued out to you. I'm setting bond at $20,000 and it's a surety bond. I think anything else would raise eyebrows in County Court at Law 1, but that I believe that is good, right, and just, because much of it, aside from the business, unless you learn anything different, is real estate. And if there's any, I don't have no reason to believe that it will be lost or misused, but real estate is easily recoverable more than cash. So I think 20,000 surety is good, right, and just. The court has granted your request, signed an order. The inventory on your mother's case is due on or before August the 4th, 2026 at 2 p.m. Mr. Knudsen, do you have the oath and bond for Ms. Bunk to execute? Yes, sir.
Okay, Judge, my client is signing the oath of independent administration. I'll tender that to the clerk. And if I can get the surety bond filed with the court this afternoon, she'll sign as surety, and I mean, maybe either her father or myself will sign as surety.
Sure.
For the 20,000, and we'll file that promptly by the end of the day.
Very well. Ms.
And
Bunk.
we appreciate everything, Judge.
Yes, sir. Ms. Bunk, do you have any questions for the court?
I don't, thank you.
Mr. Nixon, do you have any questions?
No.
The court wishes both of you well, and you have the court's condolences.
Thank you.
Have a good day.
Thank you, Judge. That's all I have, maybe.
Yes, sir. Have a good day.
You too, Your Honor.
Next in person is Counsel Jose Gabriel Loredo, page 5, number 14.
Vidal Rodriguez versus Ilsa Gonzalez Rodriguez, cause number 2026 FLA 98C3. Court marks Mr. Loredo present in person. Ms. Anderson, are you present?
Good morning, Your Honor. Yes, I'm present for Mrs. Gonzalez.
Good morning, Ms. Anderson. Good morning, Mr. Loredo.
Good morning, Your Honor.
Mr. Rodriguez, Ms. Rodriguez, are you present? Court finds neither party present. Counsel, what is the announcement?
Your Honor, we're here for pretrial. There's nothing to pretry at this time. We do have a TOM date for June 18th. So we're gonna try to work on reaching an agreement by then.
That is correct, Your Honor.
All right. Well, I certainly wish the parties well and each of you well as you negotiate this case. I'll hear any not agreed to issues, pending issues on June the 18th. Good luck to all.
Thank you, Your Honor.
Thank you, Judge.
Any other cases for either?
No, Your Honor.
Good to see you both. Have a great day.
Thank you.
All right.
Next in person is Counsel Jose Arce, page 6, number 16.
Felicitas Garcia versus Brian Alvarez, cause number 2026 FLA 245C3. Mr. Arce, are you present? He is not present. Call the next case.
Next in person is Counsel Eduardo Romero, page 8, number 21.
Ricardo Gallardo Soto versus Clarissa Yvette Gallardo, cause number 2026 FLA 401C3. Court marks Mrs. Cotto present by video conference. Mr. Romero present in person. Good morning to both.
Good morning, Your Honor. Good morning again, Judge.
Ricardo Soto, Clarissa Gallardo, are you present? Court finds the parties are not present. Counsel, go ahead.
Your Honor, we've set a mediation for June 11th. We're hopeful that we can settle the matter, and so we respectfully request for maybe 30 to 45 days to try to resolve the case, Your Honor.
That sounds about right, Judge Madeline Escoto. For Mr. Gallardo, we scheduled the mediation with Judge Hale, Judge, for the date that was just stated by Mr. Romero, and I think maybe 30 days should be a good enough time after that.
Well, let me ask you this. So this is a final pretrial, and you're going to mediate on June the 11th. On June the 16th, you have the trial on the merits. Do you want to keep that date? You want to convert it to a final pretrial?
Converted,
I
Your
can
Honor.
keep it. You want to keep, I'm sorry, what did he say?
Converted to the pretrial.
That's fine. That's fine.
All right. The final pretrial hearing is scheduled for June the 16th at 2 p.m. Give us a final hearing, a trial on the merits date, 30 to 45 days after that. No, 45 in case somebody requests discovery, and off you go.
That'll be August 11th at 2 p.m.
So ordered. Any objections to any of this, Mr. Romero?
No, Your Honor.
Mrs. Boto?
No objection, Judge.
All right. I wish you all very well with Judge Hale. I'm sure y'all are in good hands. Good luck to all.
Thank you, Judge.
Thank you.
Another case for counsel, Eduardo Romero, page 10, number 26.
To the estate of Jaime Rene Flores, also known as Jaime Rene Flores Gutierrez, cause number 2026 PB 438L2. Court marks Mr. Romero present in person. Mr. Fernando Sanchez, are you present? Court finds Mr. Sanchez not present. Speak into the microphone and tell the court, are you Maria Veronica Cuellar?
Yes, Judge.
Welcome to court, Ms. Cuellar. The court
Good
marks you
morning.
present in person.
Sí.
Mr. Vela, you're making an appearance in this case?
Yes, Judge, I was just retained yesterday. I spoke with Mr. Romero and requesting a short continuance for attorney preparation time and to file any pleadings that are necessary in this matter. My client does not speak English, Judge, so I'm not sure if we have an interpreter.
Court marks Mr. Vela present in person. Mr. Vela, what is the name of the person on your left?
Norma Flores, Judge.
Court marks Ms. Flores present in person. We'll begin Spanish language interpretation now. Based on all of this, Mr. Vela, your request specifically is?
Judge, I would just like a 1 week continuance, if the court will allow. I know Mr. Romero filed a temporary injunction.
Translation if available.
Su señoría, estamos pidiendo una semana que se posponga esta audiencia. Sé que el abogado Romero interpuso una orden de injunción.
And this is my first appearance, Judge.
Y esta es la primera vez que estoy ante el tribunal en este caso.
Any objection?
No, Your Honor, no objection. As I stated to Mr. Vela, as long as we can extend the current temporary restraining order, and he's agreed to that, Your Honor.
No hay objeción por parte mía, su señoría, si es que se extiende la orden judicial temporal y el abogado Vela ha acordado a eso.
Ms. Noriega, tell the court how many cases we have on June the 4th and on June the 9th.
That would actually be the probate matter, Your Honor.
On the 4th?
No, for the 9th. Because the 4th is family law. Unless you want me to push it onto family docket.
Right. So the question is how many cases on the 4th and how many cases on the 9th?
On the 9th, Your Honor, we do have a contested matter, so we cannot put on there.
All right. And on the 4th?
We have June the 4th, we have 15, Your Honor.
All right. I'm going to push it on to June the 4th at 2 p.m. Any objection to extending this TRO until then, Mr. Romero?
No, Your Honor.
Mr. Vela?
No.
All right. Ms. Cuellar, the court has extended this matter for hearing until June the 4th. Do you have any questions?
No, not at this time, sir.
We'll begin Spanish language interpretation once more. Ms. Flores, the court has extended this hearing until June the 4th.
Señora, el tribunal ha ordenado que se extienda esta audiencia hasta el día 4 de junio a las 2 de la tarde.
Do you have any questions for the court, Ms. Flores?
¿Alguna pregunta para este tribunal, señora Flores? No.
Court has heard no. All right. Keep in contact with your lawyers and I wish both of you very well. Good luck.
Manténganse en contacto con su abogado. Les deseamos lo mejor. Buena suerte a ambas.
Thank you, Judge.
Good to see you both.
Thank you.
Likewise.
Next is counsel Jose Acta, page 6, number 16.
Felicitas Garcia versus Brian Alvarez, cause number 2026 FLA 245C3. Court marks Mr. Arce present in person.
With for the respondent.
None of that was on the record, but we'll put you on recall.
I do have another matter though. I think it's on.
Correct. He's in page 9, number 24.
Standing in for Mr. Ruben Arce, Your Honor.
Well,
No,
I actually have another.
This is Filiberto Flores III versus Stacy Alexandra Hine, cause number 2026 FLC 641C3. Court marks Mr. Arce present in person, Mr. Joshua Schamberger present by video conference on behalf of the Attorney General's office. Speak into the microphone and tell the court, are you Stacy Alexandra Hine?
Yes, sir.
Welcome to court, Ms. Hine. The court marks you present in person. Ms. Hine, do you have a lawyer?
I'm currently in the process of getting one. I would like to ask for continuance if I may.
And Judge, for the record, what's happening?
Are you Filiberto Flores III?
Yes, sir, I am the.
Welcome to court, Mr. Flores. The court marks you present in person. The person to your right is your lawyer, Mr. Arce.
All right, Judge.
Go ahead.
What's happening on behalf of the petitioner, Filiberto Flores, Your Honor, I did speak with Ms. Hine, Judge. In fact, she advised me that she intended to hire counsel.
All right.
We are separate temporary orders.
Ms. Hine, so no objection to this request?
No, Judge, I advised my client.
All right. Ms. Hine, what is your email address?
Stacy.Hine321@icloud.com.
I'm gonna ask that you go much slower and spell it out for us, please.
Stacy,
Give us 1 second. Go ahead.
Stacy, STACEY .HEIN321@icloud.com.
Ms. Noriega, did you get that?
You said at the end was 321? Yes. Oh. Thank you.
All right, so just be on the lookout in your email, Ms. Hines, until the time that you hire a lawyer and they file into the case. You're responsible for keeping up with your emails. Any notices of setting information, they're going to go to that email. Likewise, and similarly, if Mr. Arce needs to send you any information or any request, that'll be sent to that email. Ms. Noriega, would you give us another setting on this temporary orders, please?
Temporary orders, Your Honor, yes, that would be June 16th at 2.
Any objection, Mr. Arce?
Is that going to be, I guess, within the 2 weeks? More or less.
No, that would be June 2nd, Your Honor, at 2 p.m.
So, yeah, Judge, if we can set it for June 22nd.
June 2nd at 2 p.m. So ordered. Mr. Flores, do you have any questions for the court?
That'll be it.
All right, keep in contact with your lawyer. Any questions for the court, Ms. Hine? Anything for the record, Mr. Schamberger?
Your Honor.
All right, I wish you both very well. Good luck. Oh, one more thing, Ms. Hine. So what this means is I've already given you sufficient time to look for a lawyer, hire a lawyer. Please do so. If you want to do so as soon as possible, because that person is going to need some time to get up to speed with your case, to give you some good information and advice. They're going to need ample time. And you can tell that person that the court is not going to grant a continuance because it's their first time. So make sure that you give them enough time to be ready to help you. All right, good luck.
Thank you.
Next case, Your Honor, Mr. Arce is standing for page 7, number 20.
Angel Jaimes versus Vanessa Vasquez, cause number 2026 FLA 372C3. Court marks Mr. Jose Arce present in person on behalf of Ruben Arce. Angel Jaimes, Vanessa Vasquez. Any other persons present? Court finds no other persons present. Mr. Arce?
If I may, this matter is the temporary order, John. What's happening standing for Ruben Arce for petitioner Angel Jaimes. At this time, the petition is not going to be urging their request for temporary orders. And I believe there's a setting for trial and merits for June 4th of this year. So
all right.
Stay on for that group.
All right, well taken. We'll come back for a trial on the merits. But has there been service?
Yeah, Judge, I believe that party respondent was served yesterday.
Well, just
I
do
don't know if it's
do the calculation and then ask Mr. Arce, Mr. Ruben Arce, to confer and to see if there's an agreement. The party may be requesting time based on insufficient or requiring more time. So, all right.
Is it set for June the 4th?
Right, June the 4th at 2. But I'll call it on that day. See where you're at.
That's fine.
All right. Any other cases for Mr. Arce?
No, Your Honor.
All right.
Just that one that I'm
yes,
confirmed still.
that's
All right. Good luck.
Next in person is Adriana Maddox, page 7, number 19.
This is Jorge Chong versus Alejandra Chong, cause number 2026 FLA 284C3. Court marks Ms. Maddox present in person, Mr. Chu present by video conference. Good morning to both.
Good morning, Judge.
Good morning, Judge. Nathan Chu present for Mr. Chong. He's logged in at my office.
Unmute your device and tell the court, are you Jorge Chong?
Yes.
Welcome to court, Mr. Chong. The court marks you present by video conference from the office of your lawyer. Are you Alejandra Chong?
Yes.
Welcome to court, Ms. Chong. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present in person. This is a trial on the merits. Counsel, go ahead.
Good morning, Judge. Adriana Maddox for Ms. Chong, and I'm requesting a continuance on this matter. We just recently entered agreed temporary orders. This, I believe, is our first trial on the merits setting. I need to conduct some discovery regarding some of the property issues. Additionally, the parties are parents of two young children who both have special needs. And so I also need to conduct discovery on those matters as well. So I am respectfully requesting that the court reset this for a final pretrial and a trial date.
Ms. Maddox, I'm going to tender the filed temporary orders. I'm going to tender those to the coordinator, and the coordinator can tender them to you. I don't know what was filed, but what was filed doesn't have your signature. So review it and see if that's the version that you and your client agreed to.
I believe I had sent a revised version of this.
It's a good thing I asked.
And so I just don't, if I could send my proposed revisions to Mr. Chu, and then we can take it from there.
Let me ask the clerk's office, other than this version, was any other version filed?
Your Honor.
Ms. Maddox, the terms of the agreement are they in writing in any other place, in email or Rule 11 or any other format?
I would have to check my file, Your Honor.
If I may, Your Honor,
Yes.
there was a Rule 11 agreement on April 1st.
Is it
signed by the court March 31st?
on temporary orders?
No, Your Honor.
So the only thing, Judge, is that this temporary order doesn't address it doesn't address the children at all. And it doesn't, other than just to say no child support, and it doesn't address any other expenses besides the home mortgage and the utilities. And so I would like to modify it to include conservatorship of the children.
Well, I tell you what, folks, this is a first setting, so it's well taken, but let's do this. Instead of 2, the court's going to give 3, because it sounds like you're still, at least in writing, not on the same page. So give us a temporary order setting in 2 weeks.
Temporary order setting in 2 weeks is June 4th at 2 p.m.
And now give us a final pretrial hearing 4 to 6 weeks after that.
4 to 6 weeks after that. I believe we won't have available till
Just give us the date.
July 7th at 2 p.m.
And a final hearing 4 to 6 weeks after that.
That'll be August 11th at 2 p.m.
Any objections to those dates, Mr. Chu?
No objection, Judge.
Ms. Maddox?
No objection.
Mr. Chong, the court has given what's called a scheduling order so that this case is, you know exactly what's going to happen at each benchmark. Keep in contact with your lawyer. Do you have any questions for the court, Mr. Chong?
No.
Mr. Chong, do you have any questions?
No.
Ms. Chong, do you have any questions?
No,
I wish you both very well. Keep in contact with your lawyers.
thank you.
Any other cases for Ms. Maddox? Good to see you. Have a good day.
Next in person is Councilor Julia Rubio, case number 1.
Daniel Garcia versus Ana Karen Manrique, cause number 2012 CVL 325C3. Court marks Ms. Rubio present in person. Good morning, Ms. Rubio. Very good, thank you. Ms. Figueroa, are you present? Court marks Ms. Figueroa not present. Court marks Ms. Garcia present by video conference, as is Mr. Joshua Schomburger, present by video conference on behalf of the Attorney General's office. Daniel Garcia, Ana Karen Manrique, any parties present? Court finds no parties are present. Counsel, what is the announcement?
Ms. Figueroa filed a motion for continuance, Judge. I don't object. We just request that we be set, if at all possible, in the next couple of weeks, or 3 if necessary, for TOM. The parties had their son's awards, as has been announced many times this morning, and we actually engaged in pretty productive conversations toward a possible resolution, Judge. So I'm hoping that we won't need a hearing after all.
I'm gonna restate what I said earlier. I empathize. All right. Ms. Noriega, give us another setting, please.
That'll be June 16th at 2 p.m.
Any objection?
Just checking, Judge. I do have a conflict that day. Is there anything the week before? Or actually, no, any other day that week, perhaps the 18th? I know I have court with you that morning at 9.
June the 18th, Your Honor, at 9 a.m.
Any objection?
No, Judge.
Ms. Rubio, any objection?
None for me, Judge.
All right. June the 18th at 9 a.m. All right. Good luck to all.
Thank you, Judge. May I be excused?
Good to see you. Have a great day.
Next online is Council Matter Escoto, page 8, number 23.
Jesus Ricardo Ramirez Jr. versus Vanessa Guardiola, cause number 2026 FLC 338C3. Court marks Mrs. Scotto present by video conference. Javier Guzman, are you present? Court marks Mr. Guzman not present. Jesus Ramirez, Vanessa Guardiola, any parties present? Court finds no parties present. Mrs. Scotto?
Madeline Escoto for Mr. Ramirez, Judge. Mr. Guzman filed a motion for continuance on this particular case. You just signed the temporary orders, and we just need additional time to finalize this case, Judge. It's a SAPSR. And I'm unopposed to the continuance. And he texted me this morning, Judge, if I could make the announcement for him.
Sure. We'll take it on all fronts, particularly first setting, recent temporary orders signed. We'll take it on all fronts. Give us a setting, Ms. Noriega.
30 days, Your Honor. That'll be July 7th at 2 p.m.
All right, so ordered.
Okay. And that's all I have, Judge. May I be excused?
Have a great day. Good to see
You
you.
too, Judge. Stay safe.
Next online is Council Brenda Anderson, page 3, number 10.
Page
Wait, I'm sorry, Judge. Hold on.
4, number 10. Jose
Yes.
Leija versus Claudia Isela Leija Rodriguez, cause number 2025 FLB 1604C3. Good morning, Ms. Anderson.
Good morning, Judge. Brenda Anderson, present for Jose Leija, who's petitioner.
Court marks you present by
And I
video
believe he-
conference. Jose
believe
Leija,
he was
Claudia
locked
Rodriguez,
on.
are you present? Court finds neither party present. One more time. Jose Leija, Claudia Rodriguez.
Then present online, Your Honor.
All right, Ms. Anderson.
Judge, in this case, there hasn't been service on respondent because the parties were attempting to reconcile. And my client is asking if the court would consider just one last reset of 2 months to see if they're gonna proceed with the divorce, and therefore I'll get her served, or he'll just end up non-suiting.
Well taken, but questions, Miss Anderson, are there any children of the marriage?
No, Judge.
Ms. Noriega, give us a setting in mid to late July, please.
July 28th at 2 p.m.
All right, we'll come back on that date. Any other cases
Okay,
for
thank you.
Ms. Anderson?
Yes, Judge.
Number 17.
Gabriela Guerra versus Victor Guerra, cause number 2026 FLA 272C3. Court marks Ms. Anderson present by video conference. Gabriela Guerra, Victor Guerra. Any parties present? Court notes no parties are present. Ms. Anderson?
Judge, in this case, I represent petitioner Gabriela Guerra and the parties, I believe the parties have reached an agreement and I did prepare an agreed divorce decree and a proof of affidavit that have been signed except for pending respondent signature on the decree. So if maybe we could have a decree due date.
Do you want an orders due date so that it's off the calendar, or do you want an entry of judgment so that it's like on a specific date? In court. You want a court setting?
Let's do an entry just in case he does not sign.
All right, let's do a court setting, an entry of judgment date.
July 7th at 2 p.m.
All right,
Okay.
we'll come back on July 7th at 2 on this matter. But if you get it filed, no need to sweat any of it.
Okay, great. Thank you, Judge.
Any other cases?
And that's all I have.
Have a great day. Good to see you.
Thank you, you too. Bye-bye.
Next online is Council Nathan Chu, page 4, number 11.
This is in the interest of Samantha Lee Ramos, cause number 2025 FLK 992C3. Court marked Mr. Chu present by video conference.
Good morning, Judge. Nathan Chu present for Ms. Ramos. Ms. Ramos did just yesterday hire me to do the termination adoption, Judge. So if I can get about a 45-day reset on this one so that I can file the termination adoption.
If proven, that would be likely in the child's best interest. I remember that. So well taken. Give us a setting in 45 to 60, please.
Yes, that'll be July 28th at 2 p.m.
Plenty of time to work on this, get all the legal requirements met, and hopefully this will be heard, considered, and possibly even granted before the school year begins. Very good. Ms. Ramos, do you have any questions for the court?
No.
I'm glad that you and your husband are talking about these things. I encourage you to continue to do that, to continue talking to Mr. Chu, and then I'll call this case for a final hearing on July 28th at 2. I wish your family well.
Thank you.
Any other cases for Mr. Chu? Good to see you, counsel. Have a good day.
Thank you, Judge. Bye-bye.
Next, Your Honor, is Counsel.
Next, Your Honor, online is Council Melissa Saldana, page 3, number 6.
That case is on recall. Ms. Saldana, do you have an announcement on the case with Ms. Soto? Next case.
Oh, okay.
No, I believe that.
Hello. Online is Council Juan Garcia, page 2, number 3.
And for Cassandra Montemayor versus Juan Hector Martinez, class numbers are 2013 CBW 1349C3 and 2026 FLF 312C3. Court marks Mr. Garcia present by video conference. Julio Garcia, are you present? Court finds Mr. Garcia not present. All right. Cassandra Montemayor, are you present?
I think she's present, Your Honor, under Cassandra Villa.
All right, court marks Ms. Villa present by video conference. Are you Manuel Villa?
Good morning, Your Honor. Yes, I am.
Welcome to court, Mr. Villa. The court marks you present by video conference. Juan Hector Martinez, are you present? Court finds Mr. Martinez not present. Court finds Mr. Joshua Schamberger present by video conference. On behalf of the Attorney General's office, Mr. Garcia, what is the announcement?
In this case, Your Honor, I conferred with Mr. Garcia and we agreed to an ad litem, Your Honor. I submitted an order. We agreed on Daniela Martinez, Your Honor.
All right, so knowing that Ms. Martinez, looking at this now, Ms. Martinez will be appointed by agreement. How much time do you believe would be reasonable and necessary for her to evaluate this case and perform her duties?
Somewhere between 30 to 45 days, Your Honor.
All right, give us a setting and 45 days on both cases, please.
Yes, Your Honor, that'll be available July 7th at 2 p.m.
Court will set both cases on the same day. Ms. Villa, do you have any questions for the court?
No, Your Honor.
Mr. Villa, do you have any questions?
No, Your Honor.
All right, please make yourselves available to Ms. Martinez. She'll be conferring with you, asking you some questions. Just make yourself available so that we're ready to proceed on July the 7th. I wish all persons well. Good luck.
We'll get right on it, Judge. Thank you so much.
Thank you.
Next case, Your Honor, it's page 3, number 7.
Melissa Monet Cortez versus Brian Alexander Hale, cause number 2024 FLI 785C3. Court marks Mr. Garcia present by video conference. Silverio Martinez, are you present? Court marks Mr. Martinez not present. Are you Melissa Cortez?
Yes, Your Honor.
Welcome to court, Ms. Cortez. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present by video conference as well. Brian Alexander Hale, are you present? Court marks Mr. Hale not present. Court marks Mr. Joshua Schamberger present by video conference. Mr. Garcia, what is the announcement?
I think for today, Your Honor, it was set to establish Mr. Hale as a father. There was also a termination by Mr. Martinez. Mike, I already spoke to Mr. Martinez, but it was about a month ago. I also spoke to my client, Ms. Cortez. She was in agreement to do the termination. She was in agreement with waiving any back pay, Your Honor, in order to get the termination done. But I don't see Mr. Martinez today.
Well, Mr. Schamberger, anything to add on the record?
Yes, Your Honor. So the state would oppose a straight termination. There's not an adoption pled for, correct? It's just a straight termination?
Correct.
Yeah, we oppose those as far as how it would be in the child's best interest.
All right. So now you know, Mr. Garcia, the state objects to the termination. This is only a final pretrial hearing. There's nothing for the court to consider on paternity since Mr. Martinez isn't here. We're coming back for a final hearing on the SAPSER on June the 18th and a final hearing on the termination on July the 9th as already scheduled. But keeping in mind that the court back in March 31st, the court appointed an attorney ad litem or granted it, and the orders were due on April the 27th. They've not been turned in. So it's possible that we get to the final hearing on the SAPSER, the termination, without an ad litem, and then we can't proceed. Or if it's filed much later, then that person may not be ready with a recommendation. So let me restate an orders due date for the appointment of ad litem. The orders are due on or before?
June 29th at 12 noon by submission.
Which is 10 days after the final hearing. Well, Mr. Garcia, can you just file them by Friday?
I can, Your Honor.
All right, the orders are due on or before May 22nd. All right, so just It's the blank order. I'll fill in and that'll give the ad litem a little bit less than a month to do the work. All right, Ms. Cortez, do you have any questions for the court?
No, Your Honor.
Anything else on this case, Mr. Garcia?
No, Your Honor.
Mr. Schamberger?
To clarify then, just so the order would be prepared by Mr. Garcia due Friday, and then the next setting is June 18th.
For a final hearing on the SAPSR, and then a final hearing on the termination on July the 9th at 2. Yes.
And on June 18th, that's at 9 a.m. or 2 a.m. or 2 p.m., Your Honor.
June 18th at 9 a.m.
Thank you, Your Honor.
All right, Ms. Cortez, good luck to you and all.
Thank you, Your Honor.
Next case is page 5, number 13.
Anthony Composto, Chantal Jasmine Composto, cause number 2026, FLA 31C3. Court marks Mr. Garcia present by video conference. Mr. Altgeld, are you present? Court finds Mr. Altgeld not present. Julio Garcia, are you present? Court finds Mr. Garcia not present. Are you Anthony Composto?
Yes, sir.
Court marks you present by video conference. As you can see and hear from your device, your lawyer is present by video conference. Court also calls companion case Chantal Composto versus Anthony Composto, cause number 2026, FLG 782C3. Court marks Mr. Juan Garcia present by video conference, Anthony Composto present by video conference, Julio Garcia not present, George Altgeld not present, Chantal Composto not present. Mr. Garcia, what is the announcement?
On this case, Your Honor, I only represent Mr. Composto on the divorce. I think Mr. Tellez represents him on the protective order, from what my client told me.
Mr. Composto, who represents you in the protective order case?
The protective order will be Joey Tellez, sir.
Mr. Tellez?
Your Honor, I have no objection. We just asked the court to dismiss the protective order. They failed to prove it. We're ready to proceed.
Crystallize that argument for the court, Mr. Tellez.
Your Honor, I believe there was service. This is set on the protective order. It's based on allegations regarding alleged abuse, where I really represent Mr. Composto and the allegations for injury to a child. I carbon copied and I served a response to both the investigator as well as Mr. Garcia, Mr. Altgeld, both Juan Garcia and Julio Garcia yesterday. We're ready to proceed and we announced ready.
Well, given that this, I read the affidavit, that's why I granted the ex parte protective order. But given
Which the other thing, Judge, I was going to ask the court, there is already a companion criminal divorce case. I think the filing of a separate protective order was rather redundant. They could have done it in the divorce case.
I can't undo that. But what I do know is that there were some serious allegations. There's an attached affidavit. The court granted it and then set it for this hearing. Given that there are no persons present, no lawyers, no witnesses, no parties making the request, what is your specific request with this matter, Mr. Tellez?
We asked the court to deny the request for a protective order.
All right. The request is hereby denied. Mr. Tellez, you need to prepare those orders with the same findings that the court has made, that on the date the court called it was filed, it was considered, it was granted, the case was set. On the date of the hearing, no persons were present, no lawyers, no parties, applicants, no witnesses, right? No applicants, no witnesses, and the court had no information other than to deny this request. These are the orders of the court, and the orders are due on or before
June 29th. That's one by submission.
All right. So now we go back to the underlying case, Mr. Garcia. This is a trial on the merits. What is the announcement there?
On this one, since they're not present, Your Honor, we'd be ready to proceed today.
Has Mr. Julio Garcia filed anything into the case? Let me ask the court staff and coordinator and clerk.
No, Your Honor.
Have you conferred with Mr. Julio Garcia?
He has contacted me, Your Honor. He said it because there was a protective order, he didn't have a recommendation. Uh, but we're ready to proceed on our case.
Are there, Mr. Garcia, are there temporary orders in this case?
There are, Your Honor.
And they've been signed since February. Mr. Composto, I'm going to ask you some questions. You're not on the road, so I don't presume that you're going to get yourself into any trouble based on the
Yes, sir.
type of questions I'm going to ask. If you feel that you need to interject, please do so, Mr. Garcia. Mr. Composto, I signed some temporary orders
Yes,
on
sir.
February the 3rd.
Mhm.
Have you been able to work well under those orders?
My objection to the current temporary orders is that the kids are very confused. They have no consistency or stability because they don't know which day they're going to my place or her place. So they're kind of all over the place. And my issue with that is I'm trying to develop a stability for the kids, to be there for them,
Let
to
me ask
show
you
them.
this. They may be confused, but are there specific terms and dates and times in those temporary orders?
None. There are no days as far as let's say Monday or Tuesday I'm with the kids and Wednesday, Thursday, Friday she's with the kids. We don't have any established dates, sir.
Mr. Garcia, is that true and correct? No specific dates and times?
From what I remember, yes, Your Honor, because they were living together at the time, and then my client left the house, I think a month afterwards. That's why they were just doing it by agreement.
Yes, sir.
All right. Let me do something, and then I'll ask if there's an objection. In cause number 2026 FLA 31C3, given the fact that there was a companion protective order case that the court has denied, given the fact that we're set for trial on the merits, given the fact that opposing counsel and party aren't present, and given the fact that temporary orders have not yet fully been explored, contemplated, or effectuated, the court finds that it would be in the best interest of these children to enter into temporary orders until we come back for final setting so the court can hear some additional information. Any objection to this finding, Mr. Garcia?
No, Your Honor.
Mr. Composto, raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand. Mr. Garcia, elicit testimony necessary for the court to make some decision with regard to times, dates, visitation, and so forth. Go ahead.
Oh, Your Honor. Mr. Composto, can you say your name for the record?
Anthony Composto.
And for when it comes to the visitation, what dates are you requesting that the court grant you for visits?
It's because she works out in Dewey, Texas, so I am requesting to have them during the weekdays. She commutes a lot. She's usually leaving the house. She starts her shift there at 7 a.m. She leaves the house between 5 to 5:30 a.m. There was a few days where I would try to help her out and be there before she would leave for work, but it's leaving from my place. And the kids wake up very confused when that happens. They start actually throwing tantrums and the whole deal because they don't realize I'm not there when I get to that house. Therefore, I would request to be with them on all of her work days, basically. And then when she's off, I have no issues with her being with the kids. She doesn't return home usually. It varies till 6:30, 7:30 p.m. at night. And
But can you
that's
just give us a schedule of what you're asking for, Mr. Composto?
I'm asking for primary
No,
custodial.
but with the visits, what days and times are you requesting?
Probably Monday through Friday for the most part. And maybe every other weekend if possible.
So you're requesting Monday through Friday?
Usually, what's been happening for the most part is I would pick them up from her before this order went through. I would pick them up from her around Sunday at about 7 p.m. And then I have them for most of the week. If she ever calls during the week, hey, I want to see the kids. Yeah, I have no issue
No,
bringing
no,
them
no,
to her.
but just the schedule. So you're asking for Sunday from 7 to start your visits at Sunday at 7 p.m.
Correct, sir.
And then when would the end?
Friday at dismiss normally when they dismiss from school normally.
Okay. And then would she get the weekends or you would get the weekends?
Well, I was working a lot of weekends, but it's changed now. I'm back to a regular Monday to Friday schedule, so I can be there for weekends. So that's how it was. I would, I think to be fair and consistent and to have her present for the kids and myself present for the kids without being impartial, that every other weekend would be fine.
So you're requesting that she have standard visitation?
Yes, sir.
I have no further questions, Your Honor.
If I understand the evidence and testimony correctly, Mr. Garcia, right now the children live with Miss Composto?
Yes, Your Honor, because of the protective order, the filing.
Right. So what evidence, what testimony did the court hear that would allow the court to now change conservatorship?
He did state that he had been seeing the children or has them from Sunday, I think during the week, Your Honor, and she was getting them on the weekends because of her job.
Mr. Composto, do you and Ms. Composto live in the same county or different counties?
We both live in Webb County, sir.
All right. Court is, and the children, if I understood your testimony correct me if I'm wrong, because this is what I understood, that the
Yes, sir.
children live with her.
We still have the house that's pending sale right now. She has her own apartment, even though she denies having it with another guy she works with. That's fine.
I'm not
But
asking
that's not
about,
the
I'm not
issue.
asking about any of, listen
Yes,
to my
sir.
question.
Yes, sir.
Listen
Yes,
to
sir.
my question. My question
Yes, sir.
is, with what person do your children live?
The majority of the days they live with me in my apartment. Before this order went through, for the past 6 months, it's been like that.
Do the children live with her in her apartment?
No, no, sir. When she picks them up, when I drop them off, I drop them off and she stays at the house where we own still.
She stays at the house, but you said that she has another apartment?
I know of it, yes, but she denies it. But my kids haven't been there, but they pointed it out, even driving by. Look, there it is.
So what was the point of telling the court about this apartment?
That because you asked where they stay, basically where does she live? So that's why.
Right, and then you mentioned the apartment, and then you went on to mention that they have never been there.
Right, that they pointed out. So
So the point of the court's question, where they live, and you mentioned some apartment, but you
okay.
mentioned it even though they don't live there.
They don't live there. They live between there right now. They're splitting up their times between the
Stop.
Yes,
All
sir.
right. Mr. Garcia, without knowing anything else, I don't know what the purpose of that non-responsive reference was. The court, so that there is stability as requested,
Yes,
the court finds that both parties should be joint managing conservators.
Yes, sir.
Ms. Composto, under these temporary orders, will have the exclusive right to designate their residence. Visitation will be standard per the Texas Family Code. Does your client elect extended standard?
I could just ask him, Your Honor.
Mr.
Mr.
Composto,
Composto.
do you want as much time as possible?
Yes, sir.
All right, the court will grant extended standard visitation. And the court will add in one additional day. So not only Thursdays, but also Tuesday evenings and electronic communication every day at 7 p.m. These are the temporary orders of the court, and the orders are due on or before
June 29th at 12 noon by submission.
I'm going to give you that deadline, Mr. Garcia, but my preference would be well before May 29th. So probably no later than May the 25th, so that the court can sign them and Mr. Composto can have some definitive dates so that there is no uncertainty. And then Ms. Composto and her lawyer can come back and tell the court what works, what didn't, what they object to. They didn't do it here. And we're given notice of this hearing, but they weren't present. But at least that gives your client the request he wants. That gives the children the stability that they need.
Yes, sir.
And all of this is in conformity with the evidence and testimony presented. Any questions as to these orders, Mr. Garcia?
Yeah, so my client would be, just, it's because I didn't, I'm sorry, Your Honor, I didn't, my client would be the one to designate, or what is it, Ms. Composto that
Ms.
designates?
Composto. So joint managing conservators, both parties have all the same rights, duties, responsibilities, and obligations over the children, except that Ms. Composta will have the exclusive right to determine the residence. Visitation will be extended standard per the Texas Family Code with an additional Tuesday evening visit, and each party not in possession of the children will have electronic communication with them at 7 p.m.
I got it, Your Honor, I'll prepare them.
All right. So those temporary orders will be filed by Monday, and then we'll come back for a final hearing on
How many days out, the next available?
in July.
Yes,
Yes.
that'll be July 7th at 2 p.m.
We'll come back on July 7th at 2 p.m. Mr. Composto, do you have any questions for the court?
Yes, sir. Would it be possible to add a right of first refusal to those temporary orders?
Flesh that out for the court, Mr. Garcia.
I think what he's trying to say, Your Honor, is that in case that she can't take care of the kids, he wants to be the first one to be able to babysit the children.
Sure. Correct.
Well taken and so ordered. If any person or party is not available for 2 hours, then there will be a right of first refusal. Include that in those orders. All right, Mr. Composto, I wish both you and Mrs. Composto well. More importantly, I wish your children all the best. Good luck.
Thank you, Your Honor. Thank you.
Thank you, Your Honor. I think that's all I have. May I be excused?
Good to see you, Mr. Garcia. Have a great day.
Same here, Judge. You too. Thank you.
Next on line, Leticia Garcia, page 8, number 22.
Elizabeth Marino versus Jesus Antonio Chapa Cavazos, cause number 2026 FLA 694C3. Good morning, Ms. Garcia.
Good morning again, Judge.
Good morning. Court marks you present by video conference. Elizabeth Marino, Jesus Cavazos. Any person present? So noted, counsel.
Your Honor, yesterday I filed a continuance. They are both at the award ceremony again for their son. And I did have the chance to meet with Mr. Chapa, who is pro se. He did bring me some of his financial information 2 days ago, and I requested really short reset, perhaps maybe 10 to 14 days at the very most.
Well taken. Ms.
Thank you,
Marino,
Judge.
give us a setting in 10 to 14.
Yes, Your Honor, that'll be June 2nd at 2 p.m.
All right, we'll come back on that day. I continue to empathize. Good luck to all.
Thank you, Judge. Have a good day.
You too. Great to see you.
Good to see you, Judge.
Next online is Counsel Russell Jordan, page 2, number 5.
Ruth Garcia, Gabriel Steve Juarez, cause number 2016 CVW 604C3. Good morning, Mr. Jordan.
Good morning, Your Honor.
Court marks you
I have
present.
filed with the court a motion to, yes, sir,
Video
I'm sorry.
conference. Ms. Capello, are you present? Court marks Ms. Capello not present. Court marks Mr. Joshua Schamberger present by, court marks Ms. Capello present by video conference and Mr. Schamberger as well. Are you Gabriel Juarez?
Yes.
Welcome to court, Mr. Juarez. Court marks you present by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Ruth Garcia, are you present? Court marks Ms. Garcia not present. Mr. Jordan, go ahead.
Your Honor, I have a motion to modify a SAFSR that the court granted to my client on this case back in 2023, Your Honor. In late 2025, it became necessary to file a modification of that original SAFSR order. They were calling for supervised visits to be conducted through Safe Haven as opposed to the respondent's mother being the supervising party, Your Honor. We had requested of the court an appointment of an ad litem. The court appointed Ms. Capello as she was appointed and familiar with the case from 2022, Your Honor. And we were moving along nicely, at least in my opinion. But for whatever reason, there was, and this is unknown to me, there was a conflict between my client and Ms. Capello, and she has subsequently withdrawn from the case, Your Honor, leaving us without the assistance or the guidance of an ad litem. And so I have filed with the court or I'd like to re-urge a motion for the appointment of an ad litem in light of the fact that Ms. Capello has withdrawn, Your Honor.
We're set on a dismissal on a motion to modify. So the
Yes, sir.
petition to modify was filed in September.
Yes, sir.
Literally the entire school year has elapsed at this juncture. Tell the court, Mr. Jordan, what are the issues or the terms that Mr. Juarez is seeking to modify?
The supervised visitation term, Your Honor, as I mentioned, the court had originally ordered that visits with mom be supervised by her mother. There had been issues regarding mom leaving with the child, not returning with the child, not telling my client where they were. And that was the major issue to begin with. Now the major issue, Your Honor, is there has been a difficulty in retrieving the child after past visits. But now mother is not visiting it at all, Your Honor. And so the landscape has changed in that regard. And I'd ask the court to take judicial notice of the fact that mother has been served in reality, sir, and is very much aware of these court proceedings and has failed to appear or file any sort of answer or make any appearance whatsoever, sir. And that's really, I think, the most salient feature.
Under the original orders, mother had supervised visits,
Yes, Your Honor.
and Mr. Juarez wants to remove the supervision.
No, Your Honor, Mr. Juarez asked that the supervised visits now be conducted through Safe Haven and be scheduled in advance so that mom can't just pop in after visiting with the child for 6 months and say, I want my child, and then potentially leave and not return the child again, sir, is the problem, is the recurring problem.
Ms. Capello?
Can you hear me, Your Honor?
Yes, ma'am, go ahead.
Your Honor, I have filed a motion to withdraw and it was not accurately represented that I had a conflict with Mr. Jordan's client. My representation in the first in the first go around, Judge, when the decision was made to place the child with either parent was pleasant, Judge, and I thought everything had been handled in accordance with my recommendation, Judge. But it seems that this time around, when you appointed me to serve again, Judge, I attempted, and I want the court to be aware that I had immediately attempted to contact both parties as you directed in the order, Judge, and Mr. Russell, because Ms. Garcia doesn't have an attorney, and I was confronted with that they had not received the order, that they had no knowledge they had to make some deposits. And so I was patient and I continued to try to contact them. But the issue became when I contacted Ms. Garcia, Judge, she never responded, and then she left a message with my assistants in San Antonio saying that why should she have to pay anything for my representation when Mr. Juarez when I was already on the side of
Let me ask you
Mr.
this
Juarez.
question, Ms. Capello. Let me ask you because let's assume for a second, and I'll assume that there's objections by both parties or all parties. Let's assume for a second that what you're saying is absolutely correct, that Ms. Garcia has been communication with her per your motion has been unreasonably difficult. Let's assume that both parties haven't paid your fees. Do you have, so set that aside for a second, do you have an opinion as to whether a professional opinion as to whether Ms. Garcia her visit should be supervised at Safe Haven?
I do, Your Honor.
You do?
And yes, I believe that part of the reason that I made if I may elaborate, Judge?
Sure.
Part of the reason that I made a recommendation to the court about the supervised visits was because of My interview of her mother, who urged me to be cautious of the fact and her living situation was, in her opinion, at risk to her granddaughter. And so I made the recommendation of supervised visits because I did believe the child loved her mother and needed to see her mother, but based on the risks, that there needed to be something that would guarantee that the child would not be in any risk of danger,
So your
Judge.
opinion is
And
that there should be supervised visit at Safe Haven.
yes, the safe haven, I believe it would, because I'm so familiar with the safe haven, I believe that the way they're structured would ensure that the visits continue, which I believe are in the best interest of the child to be able to still continue her relationship with both parties, with both parents, Judge. But it would be structured, it would be safe, and it would guarantee that the child's safety and would not be impaired, Judge, or at risk.
All right, Ms. Capello, obviously you reached that conclusion after work, preparation, communication, conversations, and obviously, if what you're saying is true, and I have no reason to disbelieve it, then those conversations were difficult. How much do you believe are your reasonable and necessary attorney's fees for having done these services?
I am not asking the court for attorney's fees, Judge.
I have to do this. Here we go. Ms. Capello, would you raise your right hand? It takes notice that Ms. Capello's device has frozen. I was going to put her under oath and just ask if everything she said was true.
Did it freeze, Judge?
Yes, Ms. Capello, if you are,
Froze.
would you raise
It
your right
froze
hand,
for a
please?
minute. I didn't hear you.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do, Your Honor.
You may lower your hand. Ms. Capello, is everything you've told the court true and correct?
Yes, Your Honor.
Any cross, Mr. Jordan?
No, Your Honor, I don't have any cross. I think she's been able to testify to all the facts that are relevant, sir.
Mr. Juarez, I'm going to ask you to raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand, Mr. Jordan. Specifically as to the issues of supervision versus supervision at Safe Haven, go ahead.
Could you please state your full name for the record, Mr. Juarez?
Gabriel Steve Juarez.
And how many children do you have, Mr. Juarez?
One.
And you asked me to file this motion to modify on your behalf, correct?
Correct.
And what are the facts and circumstances that necessitated the filing of this motion to modify?
I'm sorry. Well,
what facts necessitated the filing of this modification of the existing order?
the fact that well, I was getting I mean, retrieval of my daughter was being an issue. Ms. Garcia was constantly, disobeying what was on the court order. Like I said, getting her back was an issue. Mainly, what prompted it was this past summer.
Let's see. And what happened this past summer, briefly, sir?
She, well, Ms. Garcia had made a false report about me being abusive to my daughter.
Was any investigation launched by any agency?
By the CPS and the Laredo Police Department, because
and what were the results of those investigations?
they were closed. I believe I got the letter out to your assistant. That it was closed. That it was closed. Yeah.
Let's see. The department issued a letter saying there was no reason to believe.
Exactly. Yes, it says rolled out for like each of the allegations. It's ruled out. The CPS investigator. Yeah.
I see. And did you have any difficulty in recovering possession of your child after
that? Yes, even after that. Yeah. I mean, pretty much there was no convincing Ms. Garcia otherwise, regardless who said what. you know.
Now, when was the last time that mother visited with a child under the supervision standards that were established in the first order, whereby maternal grandmother was the supervisor?
As far as I know, just this past summer. But again, it was proven that she wasn't that Ms. Garcia wasn't with them. No.
Okay. To be absolutely clear, mom has not visited in 6 to 8 months, 8 to 10 months. When was the last time mom visited with the child?
Yeah, about last summer, this past summer, and no effort has been made at all. No call, nothing from her part.
I see. And what you're asking the court for is to modify the supervision provision to require that visitations be scheduled with safe haven as opposed to having maternal grandmother as supervisor, correct?
Correct.
And you feel that this would be in your child's best interest. Why?
Because I mean, it's just too easy for Ms. Garcia to disobey. Honestly, like I said, I mean, this past summer, as far as further dates back, I mean, she's the supervised part. The maternal grandmother's not visiting again. My main concern is that I'm gonna have a hard time getting my daughter back, as per the order. So I mean, I feel that through safe haven, I mean, both myself and the other party are already going to be there. So I mean,
Any
it's
other
just much
questions,
easier.
Mr. Jordan?
I'm sorry, Your Honor, I didn't hear you.
Any other questions?
No, sir. I believe that covers it. If the court has questions,
Mr. Schomburger, do you have any questions for Mr. Juarez?
No, Your Honor.
Mr. Juarez, in your case, cause number 2016 CVW 604C3, the court finds that it has continuing exclusive jurisdiction over this matter. Regarding the first issue, the court finds that Ms. Capello has in fact undergone some unreasonably difficult conversations. I find that she has performed necessary services in this case. I find that she has given the court a recommendation and has done so without payment. I also find that she is not seeking any payment. I think she has been gracious with her time and with her services. I don't expect anyone, not Ms. Capello or any other person that's ever appointed by this court to work for free, and she's agreed to do that. So I hereby take all of this into consideration and I grant the withdrawal. Ms. Capello, the court thanks you for your time, services, dedication, and efforts on this matter.
Thank you, Your Honor. May I be excused?
Yes, have a great day.
Thank you.
I'll be
You
in
too.
touch with you, Ms. Capello. I'll be in touch with you. God bless you. Thank you.
Thank you. Bye-bye.
Thank you.
Regarding, so I've signed an order granting her withdrawal, but the court has now heard her recommendation and has heard sufficient testimony for the court to grant the request. Visits will be supervised at Safe Haven. These are the orders of the court, and the orders will be due on or before
June 29th at 12 noon by submission.
Anything else on this case, Mr. Jordan?
Nothing further, sir. I'll try to have that order in by the afternoon, sir. I certainly appreciate the court's time and help.
Yes, sir. Mr. Juarez, do you have any questions?
No, sir. No.
Any last things to put on the record, Mr. Schomburg?
Since it's just really a visitation modification, Mr. Jordan, you don't need to submit it to our office. We don't have any opinion on that. That may make it easier to expedite the signing of the order.
Thank you, Mr. Schamberger.
Good luck to everyone.
I believe that's all I have, Your Honor. Maybe excuse, sir.
Yes, sir. Good to see you.
Thank
Likewise, sir.
Next on line is Council Valerie Fisher, page 7, number 18.
Sara Villanueva versus Jose Luis Villanueva, cause number 2026 FLA 283C3. Good morning, Ms. Fisher.
Good morning, Your Honor. How are you?
Very good. Thank you. Court marks you present by video conference. Good morning, Mr. Santos.
Good morning, Your Honor.
Court marks you present by video conference as well. Sara Villanueva, Jose Luis Villanueva. Any parties present?
No, Your Honor.
Court finds no parties present. Counsel, what is the announcement?
Your Honor, we had an
Really?
opportunity. I'm sorry, Ms. Fisher, please.
Go ahead, Mr. Santos.
Your Honor, we had an opportunity to confer yesterday, and we anticipate that we're probably going to be able to work this case out. I was retained not too long ago. We're already talking about mediation, and we're already talking to the mediator and getting proposed dates. We're asking for a short reset of approximately 60 days if the court were to go ahead and oblige that.
Ms.
Correct, Your Honor.
All right, well taken. For the court's benefit, Mr. Santos, what is the name that you all are looking to mediate with? Who is that person?
It's Bill Kelly out of Corpus Christi. He charges a relatively fair fee, which is $450 per side for a half day. Highly successful. Really, really good.
All right, well taken. You're requesting 60 days without going into specifics, Mr. Santos, Ms. Fisher. Have you engaged in enough discovery that you think you won't need a pretrial setting, or has a discovery not happened, or are you not at a juncture where you're comfortable with where you're at with discovery?
If I may, Your Honor, I don't believe a pretrial setting would be necessary. These parties have been cooperating with each other. I believe they still reside together currently. We have an agreement, Mr. Santos and myself, to exchange INAs certainly well before the mediation date. So I don't believe we'll need a pretrial setting, Judge.
Mr. Santos?
That's correct, Your Honor.
The court has signed off on the Rule 11 agreement. Ms. Noriega, give us a trial on the merits date in 60 days, please.
Yes, Your Honor, that'll be July 7th at 2 p.m.
I'm writing that into your Rule 11. All right. Anything else on this case, Ms. Fisher?
No, Your Honor, nothing from us.
Mr. Santos?
Nothing, Your Honor.
It's good to see you both, and I wish all persons all the best at mediation. Good luck to all.
Thank you,
Thank you,
Judge.
Judge.
You as well. God bless. Have a good one.
Next case, recall is, Councilman Melissa Saldana, page 3, number 6.
Is Linda Lisette Flores versus Jolie Hernandez Quiroz, cause number 2019 FLH 1067C3. Court marks Ms. Soto present in person, Ms. Aldana present by video conference, Mr. Schomburger present by video conference. He's here on behalf of the Attorney General's office. Ms. Flores is present, and to the right of her lawyer, Mr. Quiroz is present. Mr. Hernandez Quiroz is present by video conference. Counsel, what is the announcement?
Yes, Your Honor, we've conferred and we are aware of the court's hard stop at 11:30. We did make some progress. And as I had mentioned to the court earlier, we did have an issue with our filing of this motion for enforcement last week. And Ms. Saldana's second amended motion to enforce filed last night. We've agreed to accept service to move this case along faster. So we don't have to personally serve our clients on that motion. My motion, Your Honor, is on child support. I didn't want to move forward with that today in order to have the AG's office have the appropriate time to confirm arrearages and what type of payment plan they want to do for Mr. Hernandez. And we've also agreed, part of my motion to enforce was a disclosure of Mr. Hernandez's current address as he resides in Panama. And I just want to put that on the record. It's PH Verona, Casa F 37 in Ato, Montaña, Arajan, Panama. That's where he's going to be exercising his summer visitation with the girls. My client wanted to have that address available to her. And as far as the pending motions to enforce regarding child support and daily calls, we wanted to have the court set us down for a date after the girls' summer visitation has ended with dad.
And before I ask Ms. Saldana, Ms. Soto, when would their summer visitation end?
After July 18th. I'm sorry, it would end July 18th, is what I understood.
So Ms. Noriega, give us a setting after July the 18th.
That'll be July 28th at 2 p.m.
Any objection, Ms. Soto?
No, Your Honor.
Ms. Saldana?
No, Your Honor.
Mr. Schomburger?
No, Your Honor.
All right, we'll come back on the competing motions to enforce on July 28th at 2 p.m. Well, it sounds like you all discussed a lot. Is there anything else that the court, I mean, this is an international visit, and you know, I don't know all that you discussed, but I can certainly presume that mom and dad feel comfortable enough with this agreement. Anything else for the court to consider, Ms. Soto?
So that's what part of the reason why we wanted the address on the record, Your Honor, because of course my client, it is an international visit. It is a long summer visit. And while she understands father has an absolute right to visit with the girls, and so do her girls to visit with their father, She wants to make sure that there's no issues with getting her girls back. So we wanted to have an address on record in case that happens. Now, we're not saying it's going to happen, but in case that happens, she wanted to make sure that something was on the record to make sure that these girls return.
I think there's everything good about that, Ms. Saldana.
Thank you, Your Honor. They have actually been very good at co-parenting overall. And this isn't the first trip that they go internationally, from what I've understood. And so they have a longstanding understanding that Mr. Hernandez lives in Panama. The mother has known about that. So there aren't any issues that have come in or up that would trigger any concerns. However, my client, even though he had given her the address before, agreed to give it again. And so that's why we again today gave that address.
Mr. Hernandez, would you raise your right hand?
American
Do you
Flight
solemnly
6253 with substitution complication display this flag. If you have not already done so, please make your way through security to gate 9. Doors will be closing in 4 minutes and will not reopen. Once
Mr. Hernandez, unmute your device when the announcement stops. There's an unmute button at the bottom left of you. All right, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand, sir. Is your true and correct name Jolie Hernandez Quiroz?
Yes, Your Honor.
Did you hear and understand the agreement that was told to the court by the lawyers?
Yes, Your Honor.
Is that your full agreement with Ms. Flores?
Yes, Your Honor.
Was anything left out?
No, Your Honor.
Is there anything you want to change?
No, Your Honor.
Do you believe that this agreement is in the best interest of your children?
Yes, Your Honor.
It sounded like to the court that the main issue with the agreement is that you would have to disclose the address where your children would be visiting with you over the summer. Tell the court on the record, and it's being live streamed and recorded, tell the court on the record the address that your children will be with you during the summer.
Yes, Your Honor. The address is PH Verona, House F37, Street F. Alto Montaña is the city. Arraijan is the county. Panama is the country.
Is that the information you have, Ms. Soto?
Yes, Your Honor.
Any questions for Mr. Hernandez?
No, Your Honor.
Ms. Aldana, any questions for Mr. Hernandez?
No, Your Honor.
Ms. Flores, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God? You may lower your hand. Is your true and correct name Linda Lizette Flores?
Yes.
Ms. Flores, you heard the agreement that was told to the court by the lawyers. Is that your agreement with Mr. Hernandez?
Yes.
Is that your full agreement?
Yes, sir.
Was anything left out?
No.
Is there anything you want to change?
No.
Do you believe that this agreement is in the best interest of your children? Mr. Hernandez, Ms. Flores, well taken. The court adopts and approves your agreement, finds that this agreement is in the best interest of your children. These orders are due to the court honor before.
June 29th at 12 noon by submission.
Please don't wait till then to file Ms. Soto and Ms. Saldana. And then we'll come back for a final hearing on July 28th at 2 p.m. You know what, since this is international, include, if not already there and agreed to, some daily electronic access.
It's already included in the order, Your Honor. And just to clarify, the current order does not specify the mode, but if we can have my client's daily calls to the kids be done through app close to keep track.
Any objection?
Only if it does not waive my client's position that it is intended to be direct communication between father and children, not through app.
I'm not following. The request is that daily communication be through app close, and the objection is what?
That for father, that it be through direct communication, not through app close. So mom could have her calls with the children through app close, but father is asking that his calls be direct communication with the children.
response.
So we can address it at the final hearing, Your Honor. The kids are going to be leaving on June 9th to visit with dad. When they're in Panama with dad, my client wants to call them through the app close method. Dad wouldn't be exercising daily calls during that time period because he's going to be having the kids in his possession.
So the request is for communication with mom through app close, and we'll come back for the final hearing. Any objection to that, Ms. Saldana?
Again, no, if in the future it does not affect my clients, because part of our motion for enforcement is that the calls be through direct communication, not through app close for father and children.
So no objection at this juncture, but you're reserving the right to object at a future date. Well taken. So look, put that into the order. Just know. And look, Ms. Flores, Mr. Hernandez, I don't care what you all choose or what this court orders. In other words, I don't have a preference. However, I do have part of this court. My judicial philosophy is that all persons be treated equally. It's highly unlikely that the court is going to order one thing for one person and something for someone else, whether it's all through app close or all through some other method. Just keep that in mind. And again, I'm not saying a preference for one or the other. I'm just saying I highly disfavor different things for different persons. So if we choose FaceTime for one, it's going to be FaceTime for all. If it's app close for one, it's going to be app close for all. So talk to each other about these things. It's not an issue, which is why I'm not making it an issue right now. But Ms. Aldani has already said that it will be an objection in the future. So talk to each other about these things.
Your Honor, if I may, we are requesting this because the child has expressed being uncomfortable with the recording from app close. There's a message that says this phone call is being recorded, and that the daughter has expressed not being comfortable with that.
Well, but if the daughter's uncomfortable with that, why does it only apply to mom and not dad? In other words, if you don't object to mom and she's being recorded, but you're objecting to dad and when he's recorded, then the objection is not in the best interest of the child, it's in the best interest of your client.
Okay, then I would object to it.
Overruled. App closed for both until future findings by the court. I'm telling you folks, what's good for one is good for all. And let me ask you both this before I finalize that decision. Ms. Soto, when the app closed device says that it is being recorded, do you know who has access to that recording?
I don't know who can download that, Your Honor. We can ask my client who has access to that recording.
Do you know that, Ms. Flores, raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. Is your true and correct name Linda Lizette Flores?
Yes.
Ms. Flores, what is your understanding about what app close does when it says it's recording?
Everything's recorded for both parties, me and him. So, I mean, our attorneys can also have access to that when it's recording calls. Every call is being recorded. Either I call him or he calls me when we both talk, or when it's usually him communication with my daughters.
Ms. Aldana, thoughts, comments, questions, objections?
Again, my client has expressed that the daughter is uncomfortable with that this communication is being recorded, this phone call is being recorded. And so for that purpose, for that reason, my client filed this amended motion for enforcement asking that the mother allow the calls through the phone or through the iPad, through video chat. In fact, that's what the order says is that the daily communication.
So then I guess the question the court has, Ms. Aldana, is walk the court through that logical inconsistency, that logical inconsistent position that if the daughter has expressed a concern about recordings, you're not objecting to mom. So who cares what the daughter, if she's being recorded while talking to mom? And it's not even relevant until the date after they're returned back to mom. But your objection is at the time that they now have to communicate to dad, now they have a concern and now there's an objection for recording.
Right.
Walk the court through that.
So originally I was not objecting just because we were trying to agree to things. We were trying to move this along. We're already going to cut the cord at 11:30. So I thought, okay, well, let me just work with them here. However, if it's going to affect my client's position and the little girl, then yes, I am going to object to all of it. I mean, yes, it is the child's, who's being affected.
All right.
May
So
I have a word, Your Honor?
no, because I'm going to grant your request exactly as it's come in. I'm not making, so I know we're having this information, but it doesn't affect you. Your objection would be, if what everybody's telling the court is true, your objection would really come alive at the time that they're returned to mom. So your concern will be considered at the time that your objection is not a hypothetical, but is in fact a reality. So these are the orders of the court. The orders are due on June the 29th. Mr. Hernandez, Ms. Flores, I wish you both very well. More importantly, I wish your girls a very good summer. Good luck to all.
Thank you, Your Honor.
Have a great day.
Thank you, Your Honor. And on this one also, I don't need to sign off since it's really just a visitation issue, just to make it easier for Ms. Soto and Ms. Saldana.
All right, well taken. Thank you, Mr. Schomburger.
Thank you, Your Honor. And that was the last one I had. May I be excused?
Good to see you, Mr. Schomburger. Thanks for being present.
You
Your
too,
Honor, if
Judge.
I
Yes,
may I be excused as well?
Yes, sir. Have a great day.
Thank you, Judge. By the way, I already filed the order.
Thank you.
Thank you, Judge.
Number 16 for Mr. Arce.
Felicitas Garcia, Brian Alvarez, cause number 2026 FLA 245C3. Court marks Mr. Arce present in person. Felicitas Garcia, Brian Alvarez, are you present?
Garcia is present, as is Mr. Alvarez.
Speaking to the microphone and to the court, are you Felicitas Garcia?
Yes, I am, Your Honor.
Welcome to court. You're present in person. The person to your right is your lawyer. Speaking to the microphone and to the court, are you Brian Alvarez?
Yes, Your Honor.
Welcome to court, Mr. Alvarez. The court marks you present in person. Mr. Alvarez, do you have a lawyer?
No.
Are you going forward without a lawyer?
Yes.
Court marks you self-represented. Ms. Noriega, does the court have Mr. Alvarez's email address? Mr. Alvarez, what is your email address?
Yes, we do, Your Honor.
All right, we got it. Mr. Arce.
If I may, Judge, we have an agreement. If I can put that up through my client, Ms. Garcia.
Ms. Garcia, raise your right hand, please. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand, Mr. Arce.
May I proceed, Judge? Good morning, Ms. Garcia. How are you? Ms. Garcia, can you state your name for the court, please?
My phone. Felicitas Margarita Garcia.
And Ms. Garcia, you are the petitioner in this matter, and what that means is that you are the party that filed this action with the court. Is that correct?
Yes.
Okay. And in fact, Ms. Garcia, you filed a petition requesting a divorce. At the time that you filed this request, Ms. Garcia, had you resided in Texas for at least 6 months?
Yes.
And in Webb County for at least 90 days?
Yes.
And you are asking for a divorce, Ms. Garcia, based on the fact that the marriage has become insupportable?
Yes.
There's a conflict of personalities, and you don't believe you can reconcile with Mr. Alvarez as a respondent. Is that correct?
That's correct.
Okay. Now, with regard to the children, Ms. Garcia, there are 2 children before the court. Is that right?
Yes.
And the children are Ailani Alvarez, date of birth is 6/26/2023, as well as Madeline Alvarez, date of birth is November 16, 2025. Is that correct?
Yes.
Okay. And with regards to the children, Ms. Garcia, and having discussed the matter with Mr. Alvarez, responded, there is an agreement that both parties be named joint managing conservators. Is that correct?
Yes.
Okay. And in that same regards, Ms. Garcia, there is also an understanding and an agreement that you, the mother, Ms. Garcia, be named as a party having the exclusive right to designate the primary residence of both children. Is that correct?
Yes.
Okay. Now, as far as access or visitation for Mr. Alvarez's father, there is an understanding and an agreement that with regards to the older child, Ailani, that Mr. Alvarez will be allowed to visit or have access to the child on the first, third, and fifth weekends of the month, from Friday to Sunday, from 6 p.m. to 6 p.m. Is that correct?
Yes.
As well as every Wednesday of the week from 6 p.m. to 8 p.m. Is that right?
Yes.
Okay. And with regards to the younger child, Madeline, there is an agreement that access and visitation for that child take place on the first, third, and fourth weekends of the month, Saturday and Sunday from 1 p.m. to 6 p.m. Is that correct?
Yes.
As well as every Wednesday from 6 p.m. to 8 p.m. Is that right?
Yes.
Okay. With the understanding, Ms. Garcia,
that when the children both turn 3, that the standard possession order that's provided by the standard possession order that's provided by the Texas Family Code will apply. Is that right?
Yes.
I've explained what that is to you. You understand what those terms include, and you're in agreement that Mr. Ives have possession, standard possession after both children turn 3.
Yes.
Okay. Now, with regards to support for the children, Ms. Garcia, there's an agreement that for both children, that Mr. Alvarez will pay the amount of 140 on a weekly basis. Is that correct?
Yes.
And that there will be a step down when the older child, Ailani, turns or emancipates to the amount of $112 weekly. Is that
Yes.
correct?
Yes.
Okay. There's also, as far as medical support, my understanding, Ms. Garcia, that both children are presently under Medicaid, correct?
Yes, correct.
Okay. And so that Mr. Alvarez has agreed to reimbursement to the state of Texas in the amount of $50 monthly. Is that correct?
Yes.
Okay. With regards to any communications between yourself and Mr. Alvarez, that'll take place using the app Close. Is that right?
Yes.
Okay. And there also is a provision or an agreement that there'll be daily video calls both ways on a daily basis for 15 to 20 minutes daily at 7 p.m. Correct?
Yes.
Okay. Now, I believe that covers all the matters with regards to the children. With regards to property, there basically really wasn't any, Ms. Garcia, is my understanding, and you've agreed that, well, the parties have agreed to keep whatever they have in personal effects and personal belongings that they have in their possession, that each party keeps that personal property. Is that correct?
Yes.
There was a vehicle. Other than that, there was a vehicle, the 2019 Nissan Rogue, that's present in your possession, that's under Mr. Alvarez's name, and Mr. Alvarez has agreed to transfer title to your name. Is that correct?
Yes.
Judge, we're asking that be done. Mr. Alvarez had already agreed to this, but that be done by next Monday, May 25th of this year. Mr. Alvarez has also agreed, as far as any kind of community debt, Mr. Alvarez has also agreed, besides, obviously, you're all paying your respective debt that you all have in your respective names. Mr. Alvarez has also agreed, based on the prior court order, that he paid the amount of $600.14 that's owed to Hillside Crossing Apartments, which is located at 1019 East Hillside Road. And although Mr. Alvarez was already ordered to pay this by before April the 15th of this year, that he court allow him at least another couple of weeks, so at least June the 2nd of this year to pay that. Is that correct?
Yes.
Okay. And also there's another debt owed to, as an overdraft, to Wells Fargo Bank on the amount of $343.58. Again, Mr. Alvarez had been previously ordered to pay this on before April 15th of 2026. But you're allowing him to pay that if he already hasn't done so by before June 2nd of this year. Is that correct?
Yes.
And as with regards to the orders affecting the children, Ms. Garcia, as far as you're being named as joint conservators with your designation, you're having the right to designate, and Mr. Alvarez having those specific rights with regards to access and visitation, as well as child support and medical provisions. Do you believe that that's in the best interest of the children, Ms.?
Yes, I do.
Okay. And do you believe that as far as what was stated with regards to the division of property, as well as any kind of debt, that's a fair and equitable division with regards to the marital property?
Yes.
I believe that's all I have.
Mr. Alvarez, do you have any questions for Ms. Garcia?
No.
Is there anything that you would like to tell the court?
No.
Mr. Alvarez, I'm going to ask that you raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand. Is your true and correct name Brian Alvarez?
Yes.
One more time, Mr. Alvarez. Is there anything you would like to tell the court?
No.
Have you heard all of the testimony, Ms. Garcia?
Yes.
Is there anything you disagree with?
No.
Do you believe that this request and this agreement is in fact in the best interest of your children?
Yes.
Anything else on this case, Mr. Arce?
Nothing else.
Mr. Alvarez, Ms. Garcia, in your case, cause number 2026 FLA 245C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage. Unfortunately, that marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that you have 2 children that were born in the marriage. No other children were born, adopted, or are expected. The court finds that you have an agreement regarding your children. Both of you are hereby appointed as joint managing conservators over your children, which means both of you have the same rights, duties, responsibilities, and obligations over your children, except that you, Ms. Garcia, will have the exclusive right to determine their residence. The court hereby adopts and approves your agreement in full and finds that it is, in fact, in your 2 children's best interest. The court finds that there is no community property to divide, but the court hereby adopts and approves your agreement regarding that division. It is a just and right division. At this time, Ms. Garcia and Mr. Alvarez, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due to the court honor before.
Twelve by submission.
Judge, if I may, there was one thing I did leave out. This is part of the temporary orders on, we're also going to be asking that it be made. In fact, I discussed it with Mr.
How are there temporary orders if you're set for trial on merits?
No, they were part of the temporary. A part that I did not include, Judge, with regards to the exchange, pickup and exchanges, Judge. They're going to take place by the parties themselves at the Walmart Supercenter, located at 4401 Highway 83. And they've been taking place at the Melrose Family Fashion Store. So we're also asking.
Is this your agreement, Ms. Garcia?
Yes.
Is this your agreement, Mr. Alvarez?
Yes. I had a question. They added the Friday to Sunday for Ailani. Just want to make sure that when I can, because of work, it's not going to affect me if I just let her know in advance that I'm not going to be able to take care of them overnight.
How much time does your employer usually give you before you know that you're going to be unavailable? A week before you'll know. Do you have any objection to letting Ms. Garcia know at least 72 hours, 3 days before?
Okay.
Any objection?
No.
So ordered. Include those in the orders.
That's fine.
Anything else? Do you have any questions for the court, Mr. Alvarez?
No.
Any questions for the court, Ms. Garcia?
There you go.
I wish you both well. More importantly, I wish your children all the best.
Thank you.
Good luck.
May I be excused?
Yes. Do we have one case pending?
On the docket, but not, it hasn't been called, Your Honor.
Page 6, number 15. Argemilla Ramos versus Noé Ramos, cause number 2026 FLA 127C3. Fred Trevino, are you present?
Not present, Your Honor.
Mr. or Mrs. Ramos, any other parties present?
None present at this time.
Court finds neither parties are present. This is a second setting. Give us a third setting, last setting.
Your Honor, that'll be July 28th at 2 p.m.
Ms. Noriega, have all cases been called on today's docket?
Yes, Your Honor.
All right, that concludes this docket. Stand by.
Thank you.
To the staff. We'll be right back.